All right. Make a closing argument.
Yes, Your Honor.
Okay.
Good morning. Granville Ritchie remains innocent. The presumption of innocence remains. It doesn't matter how many times the state of Florida, through the prosecutor, Mr. Harmon, stands up here and tells you that he has proven by evidence, crystal clear, he says, evidence, that Granville Ritchie murdered Felicia Williams, that Granville Ritchie committed sexual battery against Felicia Williams, and that Granville Ritchie committed aggravated battery against Felicia Williams. He has simply failed. And so because he knows he's failed and because he knows he cannot prove and has not proven those allegations, he wants to tell you that he has proven it, that it's crystal clear. Members of the jury, what happened to Felicia Williams is absolutely horrific. No family, no little girl should ever have to suffer as Felicia Williams has suffered. No mother should ever have to suffer as her parents have suffered. No sibling should ever have to suffer as her siblings have suffered. But that being said, we as a nation, for over 200 years, have said that when the state points the finger at a fellow citizen and says that he committed these horrible crimes, they better present evidence. They better present evidence that Granville Ritchie, in fact, committed these crimes, and they have not. Some of you may say, well, Mr. Brunvan, you say he's innocent. You didn't prove that he was innocent. Well, guess not. You're absolutely right. I have not proven that he's innocent. But the law is that until and unless the state of Florida proves beyond a reasonable doubt their allegations, the presumption remains. Some of you may say, I wish we could have heard from Granville Ritchie. We all understand that. You indicated in jury selection, sure, that's a normal tendency. We want to hear from the accused. But we have recognized for over 200 years that not only can the fact that someone doesn't take the stand not be taken into consideration, it can be in no way considered as you evaluate the evidence in this case. No way whatsoever. Mr. Harmon, in his opening statements, talked about Ebony Wilder. Talked about Ebony Wilder as the loving godmother. Ebony Wiley, who took Felicia Williams on walks and bike rides. Ebony Wiley, who took her to church, fed the ducks at the pond. And he said ecstasy made her feel amorous and spiritual. What he didn't mention was the fact that Felicia Williams' family never said that Ebony Wiley could be the godmother of Felicia Williams. They'd never asked her to be godmother of Felicia Williams. What he failed to say was that when she's under the influence of ecstasy, evidently she feels like Satan's trapped in her mind. Didn't mention that in an opening statement. That didn't seem to be important to the state of Florida. Members of the jury, in evaluating the evidence against Granville Ritchie, you need to look at all the evidence that was presented in this trial. You need to consider everything that was presented. And you need to ask yourselves, did the state of Florida prove the allegations against Mr. Ritchie? And I respectfully will suggest, if you do that, if you follow the instructions and you look at the evidence that was presented, the only conclusion is that it fails. It absolutely fails. Now, what do we know? What evidence was presented? There is evidence that Ebony Wiley a few days prior to May 16th of 2014, had an encounter with Felicia Williams and her sister, where Ebony Wiley is yelling at them, cussing at them, because he's apparently upset with them. There is evidence that around the same time period that she meets Granville Ritchie, and there is evidence that on May 16th, Granville Ritchie, Ebony Wiley, and Felicia Williams go to the apartment, Dora Loke's apartment. There's evidence of that. At some point, Ebony Wiley leaves the apartment. She's there for a little bit of time. She then leaves, supposedly to get some marijuana, comes back. There's some issues as far as getting back into the gate. And you can see, if you look at the evidence of the login information to the gate, that the numbers are punched in there. It's almost the correct number, but it's not exactly the correct number. Is that because Ebony Wiley was misled? Or is that because she just got the number wrong? Okay? We don't know. What we do know is that when you look at the apartment after the fact, when law enforcement goes into the apartment after the fact, when Felicia Williams is missing, there's no signs of a struggle in that apartment. There's no DNA evidence left by Felicia Williams that you would expect if there is a struggle in that apartment. None. No hair, no skin, nothing. We know that Felicia Williams was killed. Everyone agrees. The doctor that was called by the defense agrees that it was a homicide. All doctors agree that it was a homicide. What do the doctors disagree on? Well, I would suggest to you the primary thing that they disagree on is whether or not there is any evidence of a sexual battery. Now, the medical examiner, Dr. Kurz, who's the local medical examiner who does the initial autopsy, Dr. Kurz specifically told you from that witness stand that he does not believe that the two areas that you see in the vaginal area, the two little white areas, he does not believe that those happen until after death, until after Felicia Williams was dead, and that he thinks it may happen while floating in the water. He says, he told you under oath that that is not evidence of sexual battery. Dr. Anderson indicated the same. And he also told you that there had been not only, they look to see if there's any evidence of blood. And so when they look at it, they initially look at it, and just by looking at it, they can tell that there's no evidence of blood. But to be sure, Dr. Kurtz did a microscopic examination and confirmed that there's no blood, which basically means that it's because there's no blood, there's no hemorrhaging, and therefore it happened after Felicia Williams was dead. Now, one of the, in a case like this, I'm not going to be able to tell you what happened. The evidence doesn't prove what happened, but there are snapshots of innocence. And I'm going to show you some snapshots of innocence, and I'm going to discuss some snapshots of innocence. And State's Exhibit I, photo 3, I3. When you go back to deliberate, take a look at this photo. Take a careful look at this photo. Because the suggestion was made that because the vaginal area is in such a protected area, it's unlikely that rocks, hard rocks, corals, what have you in Tampa Bay would have caused those injuries. Now, if you look at that photo, you will see that when that photo is taken, Ebony Wiley is floating face down, close to the shore, in the rocky area, with her legs spread wide apart. Okay? Is it reasonable that, as Dr. Kurz indicated, that maybe those two injuries to the vaginal area as a result of the rocks, sharp rocks that are in the water that may have penetrated that area when she is laying in the water face down with her legs spread out. Respectfully, I would suggest to you that that is reasonable. Respectfully, I would suggest to you that when two medical examiners, two trained doctors, indicate to you under oath from the witness stand that there's no evidence of a sexual battery, that is a reasonable doubt as to whether it's a sexual battery. When Mr. Harmon says, is it possible that it was from a sexual battery, that's not evidence beyond a reasonable doubt. That's not evidence beyond a reasonable doubt. Lots of things are possible. It's not his job to prove what's possible. It's his job to prove beyond a reasonable doubt that the person he is charged committed these crimes, and it fails. He fails in doing so. Let's talk about Ebony Wiley. He wants you to basically believe everything that Ebony Wiley says that helps him out. Believe it, take it as the gospel. If it helps Mr. Harmon out, believe it, take it as the gospel. But all the other lies, not so important. Ignore it, don't worry about it, forget about it. Well, the bottom line is this. When you are listening to witnesses on that witness stand, you need to consider whether or not that witness is someone who you would rely upon in making important decisions in your life. Important decisions about your affairs. Because you're asked to make an important decision about whether or not this man should be convicted of 3 horrific crimes and be killed by the state of Florida.
Objection, Your Honor.
What's the legal basis?
Can we approach?
Yes.
Based on the statements of Ebony Wiley. And I would respectfully suggest to you that you wouldn't trust Ebony Wiley to do anything that's important in your life. Anything. Is it significant that Ebony Wiley appears to be angry at Felicia Williams? Is it significant that Ebony Wiley is the one that wants to have this conversation with Felicia Williams? Is it significant that it's Ebony Wiley who tells Felicia Williams' sister, no, you can't come along? It's not Granville Ritchie, according to the evidence. It's Ebony Wiley that says you can't come along. It's significant. Why is it significant? It's significant because little Felicia Williams was brutally killed. Someone did it. Granville Ritchie did not do it. Is it reasonable that maybe Ebony Wiley did? I would respectfully suggest to you that it is. I would respectfully suggest to you that it is. She's under the influence of ecstasy or Molly. She acknowledged to you that in the past, while under the influence of ecstasy and Molly, she felt like Satan was manipulating her. You rely on your notes. Don't rely on what I say. Don't rely on what Mr. Harmon says. Listen to what we have to say, but rely on your notes to review the testimony and the evidence that was presented. Consider the fact that Ebony Wiley sat on that witness stand and lied about the incident where she's cussing out a 9-year-old and an 11-year-old a few days earlier. Lied about it. Said it didn't happen. Didn't happen. I've already indicated that there's no evidence at door looks, none whatsoever, suggesting a struggle. No hairs, no fibers, no skin cells, nothing. While, based on what Ebony Wiley tells us, and based on what Ebony Wiley tells us alone, there's a time period when Granville Ritchie and Felicia Williams are by themselves at the apartment. During that time period, towards the end of that time period, there is, according to the evidence, there's a 911 call made from that general area, from Granville Ritchie's phone. Now, Mr. Harmon will probably suggest to you that that's crystal clear evidence that Felicia Williams was calling 911, seeking help. That is one scenario that's possible. That is one possible scenario. I would respectfully suggest to you there is a multitude of scenarios that are possible. Could have been Granville Ritchie that called 911. Could have been an accidental call. Could have been we've heard that Felicia Williams, one of the things that they were going to talk to Felicia Williams about is stealing and taking people's cell phones and trying to manipulate money out of people. Could be Felicia Williams, telling Granville, give me money or I'm going to call 911 and say you're hurting me. There's all kinds of scenarios. We don't know. They don't know. They will suggest to you that it's crystal clear that it only means one thing. Members of the jury, that's not fair. It's not fair to you as members of the jury. As fellow citizens, that's not fair. The Lexus. There's no sign of the struggle in the Lexus. There's no signs of any type of DNA. They examined it. You heard from the witnesses who did the examination of the car. Nothing in that car suggests that there's a struggle. Interestingly, there's some dirt that's found on the passenger side that matches up to the dirt that's found in the vicinity of where Felicia Williams' body was located. Now, the fact that there's a lot of interesting things about the dirt evidence. One thing is, if in fact the state's theory is that Granville Ritchie drives the Lexus at a high speed down to the Courtney Campbell Causeway to drop off Felicia Williams into Tampa Bay, wouldn't it make sense for there to be some of this dirt on the driver's side? Wouldn't it make sense if he's stepping out of the car and he's walking down where this dirt is, that there would be some of this dirt on the driver's side? The other problem that we have with the dirt evidence and what it means is law enforcement reached out to NOAA, and you heard from the NOAA expert. And you heard from the NOAA expert, although they were trying to get around it in lots of different ways to suggest that it was equally likely that the body was dropped somewhere other than the southeast corner of the Courtney Campbell Causeway. But the bottom line is, there's only one spot where that expert said most likely the body was dropped on the southeast corner, after evaluating wind, currents, and the weight of the body. Now, the information that the expert received referenced the weight, 100 pounds versus 120 pounds. Is that significant? We don't know. We don't know because the state of Florida chose not to send that additional information to the expert to say, hey, does this make a difference? Does this change anything? Okay, why is this important? It's important because no one ever collected a single soil sample from the area where NOAA believes the body was most likely put into Tampa Bay. No one ever collected a single mangrove sample, whether it's red mangrove, black mangrove, or white mangrove, from the southeast side of the Courtney Campbell Causeway. No one did. Granville Ritchie is interviewed the next day. You see the interview. There's no evidence, no testimony, no suggestion that he has any defensive wounds on his arms, on his face, on his body. Both Dr. Anderson and Dr. Kurz testified that the perpetrator in this case could be a man or a woman, an adult man or a woman. That's what makes this case complicated. It makes it complicated because even if you believe that there is sufficient evidence, and understand, this is really not something you're asked to do, but if you believe that there's evidence beyond a reasonable doubt that Granville Ritchie dropped the body at the Courtney Campbell Causeway between 11:30 and 12:30 p.m., even if you believe that that's proven, and granted, there's definitely evidence that he's in that general vicinity during that time. The cell tower evidence certainly shows that he's in that general vicinity. But even if you believe that Granville Ritchie, beyond a reasonable doubt, dropped the body of Felicia Williams, which I would suggest to you is not necessarily proven beyond a reasonable doubt. But even if you believe that, the problem remains that there's no evidence as to who killed Felicia Williams. There's no evidence that Granville Ritchie had anything to do with killing Felicia Williams. I would suggest to you that there is evidence beyond a reasonable doubt, that Felicia Williams was not sexually battered. Okay? You have two medical doctors who took an oath. Okay? And yeah, do doctors sometimes disagree? Sure, we know that because Dr. Alexander and Dr. Downs disagreed on the sexual battery aspect of it. But I would suggest to you, when you have four doctors, two of them, one being the medical examiner on this case, saying no evidence of sexual battery, that's a reasonable doubt. And that alone eliminates the sexual battery count. There's no evidence that Granville Ritchie did these things. Is it reasonable, if you believe that he in fact dumped the body, is it reasonable that there may be some reasons why he would have done that if in fact that's what he did, even though he didn't kill Felicia Williams? And I would suggest to you, absolutely. If in fact Felicia Williams was killed in that apartment, and we don't know that she was or she wasn't, but if she was, and if she was killed by Ebony Wiley in that apartment, might he have concerns that no one's going to believe that Ebony Wiley did the murder? Might he have concerns that, Ebony Wiley says, you helped me get rid of the body,
Objection.
or...
Facts, not evidence.
It's a reasonable hypothesis.
Okay, stop. Again, ladies and gentlemen of the jury, this is just the attorney's closing arguments. Again, you are to rely on your memory of the evidence and the law that I give you. All right? Thank you. Proceed.
If there is a reasonable hypothesis of innocence, it means the verdict has to be not guilty. Okay? If there's there's a lot of things we don't know. But if there's a reasonable hypothesis of innocence, then the verdict has to be not guilty. And there's a lot of things that Scott Harmon has told you that there's absolutely no evidence of. None. Zero. And he'll come up and he'll say it again. And he'll be persuasive. And he'll be powerful. And he'll be loud. But the bottom line is, you go back, you look at your notes, you review and consider the evidence, you apply the law, and at the end of the day, or the end of the week, or whenever you finish deliberating on this case, there can only be one verdict. And that is not guilty as to the first degree premeditated and or felony murder, not guilty as to the sexual battery, and not guilty as to the aggravated child abuse. Members of the jury, at this point in time, I'm going to sit down. I can't talk to you anymore. I can't tell you anything else. At this time, I present to you Granville Ritchie. If you could stand for a moment, Mr. Ritchie. He's now in your hands. Thank you.
John, I'll need a minute just to install the PowerPoint.
Sure.